Judgment in the matter of UniCredit Bank against Constitutional Aircraft Leasing and UniCredit Bank against Celestial Aviation Services.
Lord Stevens will explain this judgment.
The first issue on these two appeals concerns the impact of sanctions imposed on Russia. The sanction regime imposed in 2014 following the Russian Federation's illegal annexation of Crimea included a prohibition on providing funds in pursuance of or in connection with an arrangement whose object or effect is making military goods and military technology available to a person connected with Russia or for use in Russia. It did not prohibit providing funds in relation to civilian aircraft. Between 2017 and 2020, the London branch of a German bank, UniCredit Bank GmbH, which I will refer to as the bank, issued letters of credit in connection with various leases. The leases were of civilian aircraft. The lessees were two Russian airline companies. The civilian aircraft were for use in Russia. The lessors were three Irish companies, which I will refer to as the three companies or the three Irish companies. The letters of credit were issued to the three Irish companies as security for the lessee's obligations under the leases. At the time the letters of credit were opened and the aircraft leases were entered into, the sanctions imposed on Russia did not prohibit a bank from guaranteeing payment by opening a letter of credit or from paying under a letter of credit. Following Russia's illegal invasion of Ukraine on the 22nd of February 2022, the sanction regime was amended with effect from the 1st of March 2022. The amendment to Regulation 28(3)(c) of the relevant sanction regulations meant that the bank was prohibited from providing funds in pursuance of or in connection with an arrangement whose object or effect is making restricted goods, such as civilian aircraft, available to a person connected to Russia or for use in Russia. In March 2022, the aircraft leases were terminated and the lessors demanded the return of the aircraft. However, the lessees, the two Russian airline companies, failed to return most of the aircraft. The three companies demanded payment from the bank under the letters of credit. The bank declined to make any payment, arguing that it was prohibited from doing so by virtue of the amended sanction regime until it obtained licenses to do so. The three companies contended that the bank was not prohibited from making payment under the letters of credit, as, for instance, the bank had not been prohibited from opening those letters at the time they had been issued. Furthermore, the three companies argued that the purpose of the amended sanction regime of putting pressure on Russia would not be achieved by prohibiting a German bank from making payments to three Irish companies. Therefore, they contended that the words "in connection with," which appear in the relevant sanction provision, should be construed as requiring a causal connection between the provision of the funds and making aircraft available to a person connected with Russia or for use in Russia. There is no such causal connection. The only reason why the aircraft remained in Russia was that the two Russian airline companies, in breach of the terms of their leases, failed to return them. As there is no such causal connection, the three Irish companies argued that the bank was not prohibited from making the payments under the letters of credit. The three companies brought these proceedings against the bank, seeking payment of the principal amounts under the letters of credit together with interest. After trial, but before judgment, the bank obtained licenses to make payments to the three companies, and it paid those companies the principal amounts due under the letters of credit. The three companies contended that they were entitled to interest on these principal sums. As they argued, the bank was never prohibited from making payments to them. The bank resisted an award of interest on the basis that it had been prohibited from paying the companies. It also relied on Section 44 of the Sanctions and Anti-Money Laundering Act 2018, which, it said, provided protection for its failure to pay because it held a reasonable belief that the failure to pay was in compliance with the sanction regime. The second issue raised by the bank on these cross-appeals concerns the true interpretation of Section 44. In the High Court, the three companies were successful. The judge held that the amended sanction regime did not prevent payment by the bank to the companies and that Section 44 did not protect the bank. The Court of Appeal disagreed as to the effect of the amended sanction regime. It held that the amended regime did prevent payment until the relevant licenses were obtained. Given that the bank was prevented from making payments, the parties agreed that the three companies were not entitled to interest. That disposed of the appeal before the Court of Appeal. Nevertheless, the Court of Appeal considered Section 44 and held that it would not have protected the bank. The three companies appealed to the Supreme Court, contending that the sanction regime never prohibited payment. The bank cross-appeals, contending that Section 44 does provide protection against an award of interest. The Supreme Court, in a judgment given by me, with which the other justices agree, unanimously dismisses the appeals brought by the three companies and allows the cross-appeal brought by the bank. I will now briefly summarize some of the reasons. The issue as to whether the amended sanction regime prohibits the bank from making payment to the three companies until licenses to do so are obtained depends on the true construction of the relevant statutory provision. The purpose of the sanction regulations, including Regulation 28(3)(c), is to put pressure on Russia. The method of achieving that purpose is to cast a wide net in the context that there is a licensing system that can permit payments in a deserving case. The fact that prohibiting payments under the letters of credit did not put pressure on Russia gives rise to a strong argument under the licensing regime in favor of granting a license. The net is cast wide because vital public interests are involved, and the arbiter of those interests should be public authorities involved in the licensing process. Those public authorities have institutional competence and are accountable through the relevant minister to Parliament. The Supreme Court also rejects any need for a causal connection between the provision of the funds under the letters of credit and making the aircraft available for use in Russia. The connection required by the sanction regime is between providing funds and an arrangement whose object or effect is making aircraft available to a person connected to Russia or for use in Russia. The arrangements here are the leases of the aircraft. The object of the leases does not change when they are terminated. There was a connection between the provision of the funds and those leases, whose object was to make aircraft available to the two Russian airline companies for use in Russia. The Supreme Court accordingly dismisses the three companies' appeals. The bank's cross-appeal turns on the true construction of Section 44 of the Sanctions and Anti-Money Laundering Act 2018. Does that section provide protection in respect of the bank's omission to pay under the letters of credit? The Supreme Court holds that the omission to pay falls within the language of Section 44. Section 44 does protect the bank against an action to recover a debt, an award of interest on the amount of the debt, and an award of associated costs, where, as here, the bank reasonably believed that its failure to pay the three companies was in compliance with the amended sanction regime. Accordingly, the three companies' appeals are dismissed and the bank's cross appeals are allowed.
The court is now adjourned.